A deed conveying property to two or more people is presumed to create a tenancy in common. To overcome this presumption, the deed must use clear and explicit language, manifesting the grantor's intent to create a joint tenancy with right of survivorship. In Kurpiel v. Kurpiel, the New York Supreme Court considered whether a deed's language was sufficient to create a joint tenancy. Joseph Kurpiel was the sole owner of property in Huntington, New York. In 1955, Joseph signed a deed conveying the property to himself, his wife, Jenny Kurpiel, and their son, Edward Kurpiel. The deed, which was prepared by a lawyer, conveyed the property, quote, jointly and not as tenants in common, unquote. Joseph and Jenny later divorced, and Joseph filed suit in state court to partition the property. Jenny opposed the partition action, arguing that because she and Joseph were married at the time of the conveyance, they'd taken a 1/2 undivided interest in the property as tenants by the entirety, and Edward had taken a 1/2 interest in the property as a joint tenant. Jenny argued that Joseph's lawsuit should fail because a tenant by the entirety doesn't have the right to unilaterally partition property. Joseph filed a summary judgment motion.